Land is incredibly important to all of us, but we have often disagreed about who owns it or what it should be used for. And for over 200 years in this country, there have been conflicts between Native Americans who've always lived here and new arrivals eager for land and opportunity. This program is about that struggle in Alaska. For over 200 years, the federal government tried with one policy after another to resolve those conflicts in the continental United States. But it almost always led to a loss of tribal lands. Alaska would experience the same conflicts over land, but here there was a struggle for a new kind of federal policy. This time, Alaskan Native people would be major players in forging a policy that would acknowledge their rights to the land with the Alaska Native Claims Settlement Act. But first, there would be 100 years of conflict and uncertainty with no protection of native land rights. In 1867, when the Russian flag was lowered in Alaska and the American flag was raised, most Native people had no idea Alaska was being sold. Aleuts, Athabascans, Tlingits, Haidas, Yupiks, and Inupiaqs all had Aboriginal rights to the land based on thousands of years of use and occupancy. But when Russia decided to sell her claims in Alaska to the United States for $7.2 million, the native inhabitants were not consulted. When both countries signed the Treaty of Cession agreeing to the purchase, it was the first federal policy to mention Alaska Native people. The Treaty of Cession made it clear that the original native inhabitants of Alaska were to be dealt with as other Aboriginal people in the United States. Like the Indians in the continental states, Alaska Natives were subject to American laws, but were not regarded as American citizens. The question of their native land rights would have to be answered in the future by the United States Congress. And until it was, there would be a cloud of uncertainty over the ownership of Alaska's land. Meanwhile, with the discovery of gold, the abundance of furs and fish and land, Alaska began to see a steady stream of newcomers. They stretched their nets and mined their gold on native hunting and fishing grounds. The competition for land was getting intense. In 1884, Congress passed the Organic Act, giving Alaska a territorial government and guaranteeing prospectors and church missionaries legal title to lands they were claiming. Alaska Natives, however, were not allowed to file claims because they were not considered U.S. citizens. The Organic Act did say that Alaska Native people would not be disturbed in their use and occupancy of their land, but the Act did not specify how Native people were to protect their lands from newcomers or acquire legal title. Once again, that was left up to Congress and future legislation. By 1900, 33 years after the purchase of Alaska, newcomers were becoming the majority of the population. It was becoming clear to Native people that without voting rights, it would be difficult to secure title to their land. In 1912, the Alaska Native Brotherhood organized, and 3 years later the Sisterhood followed. They worked hard to establish citizenship rights for all Native people. 12 years later, after a national struggle, Congress passed the Citizenship Act, granting voting rights to all Native Americans. It was an important step for Alaska Natives in the struggle for land rights, and in 1924, it would lead to the election of the first Native to the territorial legislature, William Paul, a Tlingit lawyer who had worked hard for Native rights. The 1940s and World War II brought the military to Alaska, and construction, roads, and more people. At the end of the war, many stayed on, and the demands for land and development grew even stronger. By the 1950s, most Alaskans were eager for statehood. In 1959, Congress approved the Alaska Statehood Act, and there was a great celebration. And because the new state needed a source of operating funds, Congress allowed Alaska to select 104 million acres, almost a third of the entire territory, as state lands. The state could then develop the resources or sell the land to make money. But Alaska Natives were disappointed. The federal government had once more put off confirming any native title to land in Alaska. The Statehood Act did say that the new state and its people would have no claim to any lands whose right or title may be held by Eskimos, Indians, or Aleuts, but it provided no legal way of protecting those land rights. And as both the state and federal governments began to select the lands they would each manage and develop, they inevitably began to choose areas that had traditionally been used and occupied by Alaska Natives. In 1961, the Atomic Energy Commission targeted the village of Point Hope for an underwater nuclear explosion that would have created a deep harbor there. The traditional hunting land around the village of Minto was in danger of being declared recreational land for Fairbanks residents. In 1963, the proposed Rampart Dam would have flooded several villages on the Yukon River. And in 1964, village land in the Dot Lake area was being divided up into lots and sold at the New York World's Fair as wilderness sites. Conflicts over the ownership and development of land were escalating all over the state, and with really no resolution in sight until 1968, when the largest oil field in North America was discovered on the North Slope of Alaska. Now native land claims would have to be settled so that an oil pipeline could be built across native lands from Prudhoe Bay to the port of Valdez, and so that oil development in Alaska could proceed. But before any settlement was achieved, the legal basis for native land rights would have to be understood.
You gotta remember, you get title to land in three ways. Somebody gives you land, you sell the land, or you win it in war. The Indian people in Alaska were never conquered, they never sold the land, and they never gave it away. So there was still some legal title to the land. And that title was whatever Congress determined it was.
But Congress was thousands of miles away, and getting a settlement would be an uphill battle for a native community that was, for the most part, spread out in small, isolated villages. Air transportation was expensive, and phone communication often didn't exist. When the Tundra Times newspaper was started in 1962, the native community finally had a way to talk to each other and to the rest of the state. Howard Rock was the founder and first editor of the Tundra Times, and he began to publish information on land claims. But because there was still no unified native political organization, there were meetings on land claims taking place in Washington, D.C. without any native representation.
We heard Senator Greening and Bartlett and Pollock were going to be getting together with the Secretary of Interior to talk about land claims, and we decided, by God, they're talking about our land, and we got to be there.
So we called a special meeting of Cook Inlet Native Association on Sunday afternoon. We explained that the state of Alaska was going back to talk about the land problem in Alaska and that the native people were not represented. Alice Brown stood up and said, "Here's $200. Anybody else?" And it went around the room. We raised $1,300 in about an hour. That was enough at that time to pay for Willie Hensley and myself to fly back to Washington, D.C.
If Alaska Natives were going to have a voice in any settlement of their land claims, they had to have a statewide political organization. In the fall of 1966, the first meeting of the Alaska Federation of Natives took place. For the first time, Aleuts, Inupiaqs, Yupiks, Athabascans, Tlinkits, and Haidas began to work together with the common goal of protecting traditional lands. And at the same time, a new identity began to emerge, a common identity as Alaska Natives. The Alaska Federation of Natives called for a federal land freeze on all Alaska lands. It would prevent everyone, the state, the federal government, and the oil companies, from doing anything on Alaska lands until a settlement was reached on native land rights.
In there we had Secretary Udall, Secretary of the Interior Udall, imposing a land freeze, telling the state, everybody, there ain't going to be any disposition of any land in the state until land claims of Alaska's Native people is resolved. You know, that focused everybody wonderfully and very, very quickly. And so it became a public policy issue that everybody had to deal with in order to get on with the development of the oil and the economic promise of our state.
One of the first steps in any settlement would be to determine how much land Alaska Natives would be entitled to. How much of Alaska's 367.7 million acres had they traditionally used and occupied?
We went into the villages and put maps up on the wall and said, show us where you trapped. Show us where you fished in the summertime. Show us where you wintered. They'd stand up and especially the old people, would march forward and draw these things. And based on those, we started drawing the common boundaries for the regions.
There were probably 40 to 50 organized tribes, which in some instances included a number of villages. They didn't have geographically drawn boundaries. They had respected boundaries based on use and occupancy, which mainly followed coastline and rivers and mountaintops.
Defining land claim boundaries was not the only difficult part of pushing for a settlement. Securing the land itself was going to be hard.
During the course of American history, it's been very difficult for the country to convey land to Indians. I mean, after all, there's maybe 50 million acres left in Indian hands in the entire country. So we pushed very hard on the land aspects of it. And I think it's damn near a miracle that we're able to get the Congress to convey land.
There was a great deal of discussion about the structure of the settlement. Should there be reservations, or should there be something different, like business corporations?
If we were under reservation status, we would always forever be under the paternalistic care of, by the Secretary of the Interior, our great white fathers, what he would be.
The federal government in 1968 was still putting $100 million a year into the reservation system. And it was a failure. They still had the worst health statistics and the worst housing. And so Congress was casting about for a different formula.
So you wound up with a corporate structure as a vehicle to convey the land into, because the underlying theme was there will be no creation of Indian reservations any longer.
We know there's a lot of opportunity in Alaska, and that land is the basis of the wealth, and we wanted to participate in that. We were not willing to let an industrial state grow up around us and stand by and not be participants. And the best way to participate, we thought, would be through the corporate structure. There was some thought given to what would work.
The next step for Native leaders was going to Congress and lobbying members for their support.
I personally made 36 round trips in 18 months from Washington, D.C. to Alaska.
Well, we had a plan, a strategy that we were going to touch base with every congressman, with every senator.
And some of them just flat said, I'll never go for it. So you had to screw up your courage to go in.
It didn't make any difference whether they're friendly with the idea. We would go and see every one of them, because they needed the information.
There was no money, there was no organizations, there was just this little bunch trying to do something, getting back to Washington and learning real fast. These are people that didn't have law degrees or business degrees.
The settlement started to grow and grow and grow, and the issue became hotter and hotter.
There came a point at which ANCSA moved out of the hands of Alaska's native people. Quite near the end, there was no question that the final decisions were going to be made essentially without us.
So arbitrarily, Congress, in its wisdom, passed the bill.
By December 17, 1971, Congress had passed the final version of ANCSA, the Alaska Native Claims Settlement Act. Alaska Natives would eventually be able to select and hold legal title to 44 million acres of land and receive $962.5 million for the land they claimed but did not receive. The land and the money were to be distributed among 12 regional corporations and 200 village corporations within those regions. Native lands would eventually equal 11% of Alaska. The state share would be 28%, and federal lands would be 60% of the state. The construction of an oil pipeline across Alaska could now proceed, and the entire state would experience an economic boom that would bring jobs and increasing development. And Alaska Natives, had they gained or lost? A new federal Indian land policy had been created, but now the question was, would that policy work for the people who had struggled so hard to achieve it?
Much of what I feel about ANCSA comes in retrospect because it was an incredibly complex bill. I mean, no one really knew what it was going to do or how it was going to work, and those people who thought they did, didn't.
The natives had, as a consequence of the Settlement Act, assets put into their hands that gave them a greater measure of control over their futures.